TCS.
Because I'm the only one.
Actually would have, but I just.
Just wanted to say hello to our folks online. We're going to start in just a few minutes. We're waiting for Dean Matthew to arrive to provide introductory remarks. So appreciate your patience. We should be starting in just a couple of minutes. Be back soon.
Gotta use ones that I don't have.
So I want to officially start the event and then introduce Dean Matthew. Just very briefly, thank you all for coming today. We are we are delighted that you're here. This is a really exciting event for us in the Environmental and Energy Law program, our first event of the 2024-25 academic year, and a very special one. We're accustomed to bringing experts in environmental law from around the country and around the world for our events and helping our audience gain tremendous insights and wisdom from those speakers. But today's event is unique in the sense that we are once again bringing experts from around the country and the world to enlighten you, but all of them are former or current environmental law fellows in our program. So this event is a showcase in the true sense of the term, that we are not only showcasing the very interesting issues that you'll be hearing about across areas like climate change, biodiversity, and environment and energy law, but you'll be hearing from folks who are very closely aligned with our program, who are essentially the best evidence of our impact, because they have gone on to have outstanding, prestigious, successful careers as environmental practitioners and academics. And so we're giving you a balance of that between those that were fellows, 3 of them, and 1 who is currently a fellow in our program. So it's a really nice, exciting mix of expertise and talent and energy that you'll be treated to today. So I did want to remind you, we have a full slate of events this fall. So please go to our program webpage, Environmental and Energy Law GW webpage. We've got 2 next week alone, and some really exciting. Our marquee event for the semester is the Shapiro Distinguished Lecture. That's October 29th, and several others, really exciting events. I wanted to give a shout out to the 1Ls for being here. Really excited to have you here as early as possible in your careers and benefit fully from the environmental law program that we have here and the resources that we have on our full-time, part-time faculty and our alumni. So you'll have more opportunities in our future events to connect with our alumni as well. And also to my students, international environmental law class students are here, and they're certainly very keenly tuned into what the speakers will share, as they are a little more familiar than the rest of us on those topics of international environmental law. So without further ado, I wanted to introduce Dean Matthew, the Dean of GW Law School. We are always so fortunate to have her introduce our events. I could go on and on about her incredible bio, but I won't, because she hates when I do that. And she's a very busy person. So as I said, we're lucky to have her here. And we'll look forward to hearing her remarks.
I'm never too busy to come and support this program, and Randy, the wonderful job that you do in bringing a plethora of events that help us to stay true to our representation of our vision, that we are helping our students equip themselves to solve some of the most pressing challenges of our time. Our planet's in danger, our environment needs your help, and this is the program that allows you to explore different ways to do that. As you heard, my name is Dana Matthew. My pronouns are she, her, and hers. And I want to welcome you to the GW Environmental Law Fellows panel provided by our Environmental and Energy Law program. You've heard why this is so special and why we're so proud that you are going to hear from our fellows. But also, we're also just hoping that you will benefit from some of the energy and enthusiasm that we have about our program generally. It was established in the beginning of the modern environmental law era and continues to expand to provide the next generation of environmental and energy lawyers with tools you need to tackle both local, state, federal, national, and international issues for this planet and its inhabitants. One of our many groundbreaking offerings is our Environmental Law Fellows program, which is unique among law schools nationwide. This program, as you will see, attracts outstanding aspiring environmental law professors who spend 2 years publishing environmental law scholarship, teaching environmental law courses, and actively participating in the day-to-day operations of our program, including editing a blog and a quarterly newsletter, managing the program's LinkedIn account, and actively contributing to the content and logistics of many events. This prepares them to be professors. The only thing they're missing is my favorite, managing HR problems. So they will do that as well. Fellows bear the title Visiting Associate Professor, and this is a really important contribution not only to these individual fellows, but also to the academy generally. Many times a law school distinguishes itself by the scholarship of our faculty, and certainly that's true of our environmental law faculty and our program. But this program in particular also distinguishes itself by publications jointly of our fellows that create new leaders in the academy. That's an incredibly important place that GW Law occupies in the legal academy. This program has achieved outstanding success by resulting in or producing not only outstanding faculty members, but also environmental lawyers and environmental advocates. Our former fellows have gone on to secure environmental law positions at Harvard, Columbia, UCLA, LSU, and Pace, as well as prestigious positions in environmental law practices, including the Commission on Environmental Cooperation in Montreal, the EPA headquarters, and today you will have an opportunity to hear from some of these very successful leaders. Today's panel, moderated by our amazing Assistant Dean for Environmental Law Studies, Randy Abate, showcases 4 exceptional GW Law environmental fellows who have pursued careers in domestic and international environmental law. The panelists will share highlights of their work with their current positions, from their current positions, and they will deliver presentations on the recent or work in progress scholarship on climate and energy justice and environmental human rights issues that they are working on. Strategic litigation at the intersection of human rights and environmental protection is exploding around the world, and you will hear perspectives on these cases by today's panel. A major recent international environmental law treaty Biodiversity Beyond Natural Jurisdiction, the BBN, or High Seas Treaty, is another major development in the field that will be addressed in today's session. So now I want to give some thanks, express some gratitude, and let you get to the program that you really came to hear. First, I want to express my sincere gratitude to Giovanna Gismondi. She's a current environmental law fellow and visiting associate professor here at GW Law. Giovanna teaches and writes in the areas of international and environmental law, international human rights law, and international dispute resolution, and is the author of the 2023 book, International Environment Law and International Human Rights Law in Investment Treaty Arbitration. I also want to say welcome to Anchiti Vithanogi. Did I say that right?
Achinti Vithanagi.
Achinti Vithanagi. Thank you. She is the Assistant Director of Environmental Law Programs and Professor of Law for a designated service for environmental law at Elizabeth Haub School of Law in Pace University. Achinti was GW's first environmental law fellow to have an international law background and is currently an SJD candidate at our law school as well. Nick Briner holds the John P. Laborde Endowed Professorship in Energy Law at Louisiana State University's Paul M. Hubert Law Center. He earned 2 law degrees here at GW, a JD and an LLM in energy and environmental law. And Caitlin McCoy is a legal officer at the Commission for the Environmental Corporation in Montreal, whose work centers primarily on energy, air quality, and climate change with an awareness of impacts on low-income communities. She holds an LLM in international environmental law from GW. Let me also take a moment to thank our environmental law program associates, Claudia Delgado and Yinzi Dai, and Dean Randy Abate himself for his hard work and all of their hard work and meticulous planning to bring today's program to fruition. Now, before closing, let me say one more thing. We have some extraordinary announcements. That is to say, we've attracted some new personnel to our environmental law program that you should know about. We are excited to welcome Dr. Chris Svensson, who's our new Assistant Dean for Energy Law. He joined us this June, and to welcome Professor Carolyn Seacott as a visiting professor in our program for the 2024-25 academic year. She teaches environmental law and is visiting us from the other George that will not be named, and she's so glad she's here. These are exciting times for our program. I welcome you with great enthusiasm. I commend this program to you and know that you'll learn a lot, enjoy one another, and use it to change the world for better.
As you can see, we're so fortunate to have Dean Matthew, and we are really delighted for her support of the program every event we have. So I just wanted to say a few housekeeping ideas that we have our online speaker, Caitlin McCoy, will start things off, but Caitlin needs to transition before the end of the panel. So we will have an opportunity for no more than 2 questions after Caitlin's presentation. And then we will move into the 3 presentations in this order from left to right from our in-person panelists. And then we will have a Q&A, an open Q&A for the in-person and the online audience. I wanted to extend a welcome to our online audience. I forgot to do that. So without further ado, I will not do any more introductions. You will hear what each speaker will be speaking about as they go through their remarks. I want to get to our program, so I'm just delighted to have these 4 outstanding panelists, and you're in for a treat of knowledge and inspiration. So without further ado, Caitlin, the floor is yours.
Thank you so much. And thank you so much, everyone, for joining today. It's such a treat to be here. I'm sad that I can't be in DC with all of you at the moment. I'm coming to you from Montreal. So thank you for accommodating me and for having me today. I have a few slides, so I'm going to go ahead and start my slideshow. Let's see if it works. Oops. All right, we're off to the races here with technical challenges. Okay, here we go. Okay. Okay, can everyone see that? We're good? Yes, okay, good. So, as you all heard in that lovely introduction, I am Caitlin McCoy, and I'm a legal officer at the Commission for Environmental Cooperation, which is headquartered in Montreal, but works between the United States, Mexico, and Canada. And I'm going to talk to you all a little bit about the submissions on enforcement matters process, which is a big part of my job here at the Commission. And that's really where I do most of my research and writing these days, in the context of our submissions. So I'll give you all a quick overview of the Commission, the submissions process, and I'll mention some statistics, and then we'll jump in, try to get a little bit of detail in on some active submissions that we have right now, because I think those examples really help you all understand what the process is and the types of issues that we are working to address these days. So the Commission for Environmental Cooperation was started back in 1994 in parallel to the NAFTA free trade agreement between Canada, Mexico, and the United States. I was lucky enough to join the Commission in January of 2021, which was just about 6 months after our new trade agreement entered into force. The USMCA, CUSMA, or TMEC, depending on the country that you're in, entered into force July 1st of 2020. So we now operate under a new parallel agreement called the Environmental Cooperation Agreement, and we implement the submissions process, which is now inside of Chapter 24, the dedicated environment chapter of the trade agreement. So our mission is facilitating cooperation and community participation, seeking to conserve and preserve the North American environment. So I'm going to make a couple references later in my presentation to the CEC Council. So I just wanted to make sure to introduce who I'm talking about up front here. So this is the governing body for the Commission, and it is composed of the environment ministers of each of our 3 countries. You can see there we have Stephen Guilbeault from Canada. We have Maria Luisa Albores from Mexico. But those of you who follow international politics may know the government of Mexico is in the midst of a transition right now as a new president, Claudia Sheinbaum, takes power. And so we will have a new Secretary of Environment here in about 2 weeks, I think. Our new secretary will be Alicia Bárcena. And as you can also see, Michael Regan representing the United States. So the provisions that really talk about the SEM process, the submissions process, inside of Chapter 24 appear in 2427 and 2428. So really kicking things off, the key thing to know is that any person of a party may file a submission asserting that a party is failing to effectively enforce its environmental laws. Let's unpack that. Lots of magic words, lots of key phrases that require definitions in there. So a person of a party refers to any individual, whether they're a citizen or a permanent resident of one of the 3 countries, a nonprofit organization, a business entity, and even a local government body. Those are the entities that can file a submission here with us at the Commission. And what they would allege is that one of the 3 countries, a party to the USMCA, is failing to effectively enforce its environmental laws. And the environmental laws that we're talking about are defined in Article 24.1. And essentially, there's a definition for each country, but it all boils down to a law passed by Congress that is enforceable by the central level of government or any regulations adopted thereunder. So in the US context, I hope you all are thinking immediately Clean Air Act, Clean Water Act, Endangered Species Act, Marine Mammal Protection Act. And yes, all of those laws and all of their regulations can be asserted in a submission. So what happens in the process is that we need to verify that submissions meet certain requirements. We have a little bit of a list of requirements. Some of them are very simple, like a submission just needs to be in writing in English, Spanish, or French, one of our 3 official languages. And some of the requirements are a little more specific, like we require that people have communicated the issues to the national government, to an authority that can do something about it in the country where it's occurring before they come to us. So we're seen as a process that comes a little later on. People need to try a domestic remedy. They need to communicate the issue to the government and give the government an opportunity to try to address the issue before filing a submission. And then we have a couple other provisions that relate to the government response and the factual record, which is kind of the culmination of the process, which is a big investigative report that I'll talk more about in just a second. So just to walk you through the steps, because I know I was just talking about that in the abstract, but the way this actually breaks down is that a submission is filed, we review it to determine whether it's eligible. We go through those criteria that I just mentioned, and we make sure that the submission meets all of those criteria. If that's the case, and we believe the submission merits a response, we will issue a determination, and then it's time for the government to respond. The government has 60 days to respond, and at that time, we sit down at the Secretariat with the government response side by side with the original submission, and we say, hey, are all of the questions raised in the submission answered here? Are all of the issues that were brought up in the submission, are they being addressed? If the answer to any of those questions is no, then we may move forward with recommending that a factual record be prepared. Like I said, a factual record is a large investigative report where we really try to dig into what's happening around the government's enforcement of these specific laws and provisions raised in the submission. So once we make that recommendation, we wait for the council members to instruct the Secretariat to move forward. So that's, like I mentioned, the council, Administrator Regan, Secretary Albores, and Minister Gilbo all need to weigh in. And once they authorize us to move forward, we then prepare a factual record. The parties are able to comment on the accuracy of the draft. It's finalized, and then the factual record can be published unless 2 council members instruct otherwise, although that's never happened in the history of the process. The process is really meant to promote the public exchange of information so that people can see what's happening with these enforcement issues in their country or in their community. We have 2 new components here, steps 6 and 7. These are new under the USMCA. As I mentioned, we transferred from our older agreement into the USMCA, and there were a couple provisions added along the way. So one is that we now have an environment committee that will review any factual record that we prepare and can recommend activities for the CEC to undertake in relation to the issues raised in the factual record. And the other is that the party in question, so the government that is the subject of the factual record, needs to provide updates to the other council members on how it's going with these enforcement issues over time. So just to give you all a little bit of data and statistics here, in the history of the SEM process, we've had 114 submissions filed. So this goes all the way back to 1994. And you can see the breakdown there by country. We have had 2 submissions involving the US and Canada. So in case that was a burning question you had, yes, a submission may address more than one country at the same time. And we've had that happen in the past. We currently have 27 factual records that have been published as part of the process. So this is what we have on deck at the moment. We currently have 9 active submissions before us. One of them comes from our former agreement, the North American Agreement on Environmental Cooperation. We have a provision that states that all submissions that were filed under the former agreement should be processed under the former agreement. So we're finishing up that now with our last submission. It's a submission that deals with hydraulic fracturing in a small community in the state of Nuevo León in Mexico. It deals with some water quality issues related to 2 wells in that community. And so we're currently in the phase where we are seeking comments from the parties on the draft. So that should be published probably around the end of the year. The next that we have is the Vaquita porpoise factual record. I'll talk about that in a little more detail on the next slide, but just so you know, that's our other factual record that we're currently preparing. I actually just got back from a whirlwind visit in northern Mexico, in the northern Baja California area, where we were going on our site visit. That's a component of the process. We actually go to the area where the issue is occurring to see close up what's happening, to meet with community members. We met with fishermen, we met with NGOs that are promoting alternative fishing gear. We met with a wide range of government agencies from across the Mexican government. So that is very much in progress as we speak. We're working on that draft. So the next few that you see, the North Atlantic right whale is a submission involving the United States. I'm going to talk about that in more detail in just a second. So I'll skip to Train Maya, which is a large-scale train project in the Yucatan Peninsula in Mexico. We have a submission related to avocado production in the state of Michoacan in Mexico that makes allegations around water quality issues, use of pesticides, climate change, deforestation, loss of biodiversity, really a wide range of issues raised in that submission. We also have a submission on agave production in the state of Jalisco, and that submission mostly focuses on water quality issues stemming from wastewater in the agave production process. Next, we have Valle de Bravo, Amanalco, which is a sub-basin outside of Mexico City, a beautiful area, but that's had really rapid development and is facing issues with water quality and water quantity. So then we go to our last submission from Mexico, which relates to illegal logging in a small area in the state of Jalisco. Finally, we have a submission involving Canada, which I'll talk about in a little bit of detail here in a moment, that relates to vessel pollution off of the Pacific coast. So as you can see, all of the submissions that I just talked about, there's 7 of them that are in kind of this waiting period right now. So you can see over on the right, the dates that the Secretariat made its recommendation that a factual record was warranted and was recommended by the Secretariat. So now we're waiting, we're pending instructions from the council members to move forward with potentially preparing factual records in all of these cases. Okay, so as promised, I'm going to talk you through 3 submissions that we have active at the moment, just so you can get a sense of who are the submitters, what are the issues raised, and get a sense of what I'm really working on these days. So first we have the Vaquita submission. So this one's interesting because it was actually filed by 4 environmental advocacy groups in the United States. So this was a submission filed by US organizations in relation to Mexico. The submission was actually filed in English, so we needed to translate it to Spanish very quickly so that the Mexican government could get an idea of what was being alleged. So they filed a submission alleging that Mexico is failing to effectively enforce its environmental laws to protect the Vaquita porpoise from decline caused by bycatch in gill nets. So in the northern Gulf of Baja California, in that area, they use gill nets to catch shrimp and other fish, which can cause really high rates of bycatch. There's another fish in that area that is also endangered. It's called the totoaba, and it is also endangered by illegal fishing. So the submission raises both species as an issue, but really focuses on the vaquita. So the vaquita is unique because it's the world's smallest cetacean, and it is the most endangered marine mammal in the world. Approximately 10 individuals remain today. And part of the reason why it's so endangered is because it has the smallest range of any cetacean. It lives in a 1,500 square mile area in the upper Gulf of California, as I just mentioned. And in relation to the vaquita, the totawaba is another large endangered fish that lives in this area. Its habitat partially overlaps. And the totawaba has become prized in recent years for its swim bladder, which is trafficked illegally to China and sold there for supposed medicinal purposes. And so this is a really interesting submission because you have issues of fishing, you have wildlife trafficking, and you have an extremely endangered species. So we're currently preparing a factual record regarding effective enforcement of Mexico's general wildlife law and some federal regulations that prohibit fishing in vaquita habitat and that prohibit the use of gill nets. Next is North Atlantic right whale. This will theoretically be our next factual record. As you could see on the list, it's the next one in chronological order. This was a submission filed by Oceana, which is an environmental advocacy group in the United States, and they filed in relation to the US government, stating that the US is failing to effectively enforce several US laws and regulations related to vessel speed limits and commercial fishing to protect the North Atlantic right whale from the two greatest threats to its continued survival, which are vessel strikes and entanglement in fishing gear. So the North Atlantic right whale is one of the world's most endangered large whale species. And like I said, the two principal human-caused sources of North Atlantic right whale mortality and serious injury are vessel strikes and entanglement. The latest estimate suggests there's around 350 right whales left. There is a southern right whale, I should also mention. So we're talking here only about the northern right whale. And fewer than 70 breeding females, which is really the number of concern. If things continue at their current pace, this species will be extinct in 2035. So it's a really important time now to take action. So we recommended preparation of a factual record in June of 2022 regarding effective enforcement of the Marine Mammal Protection Act, the Endangered Species Act, and also NEPA. Finally, our submission from Canada. This is actually one of our more recent submissions, and interesting, I think, to a lot of you perhaps, because you may be familiar with the action that the International Maritime Organization has taken to try to crack down on pollution from ships in an effort to make some progress on climate. Now, this has an unfortunate sort of side effect in that a lot of the ships that are installing scrubbers, you can install an open loop scrubber or a closed loop scrubber. Open loop scrubbers are continuously running seawater through them and discharging into the water as they go. So that's really the heart of the submission here, that asserting that Canada is failing to effectively enforce environmental laws to prevent pollution of the marine environment by vessels using these exhaust gas cleaning systems along the Pacific coast of Canada. This scrubber wash water is what we call it because these exhaust gas cleaning systems are nicknamed scrubbers. This wash water contains a lot of pollutants of concern, especially heavy metals that are being discharged into and near the critical habitat of the endangered southern resident killer whale population off the coast of British Columbia. So we recently recommended preparation of a factual record just in June of this year. So as you can see, we've been on a bit of a run with marine related submissions lately, marine species, and a wide variety of pollution issues in the marine environment. So that's what I have for you all today. Thank you for having me. I think I'm on time. Sorry if I spoke a little bit fast. I was trying to get everything in. But as you can see, I work on what comes to the commission from the people of North America, people across Mexico, the US, and Canada. They raise issues to the commission, and that's what I end up working on. So just so happens it's a lot of marine issues currently.
Thank you so much, Caitlin, for being the first. I'm very impressed that you're the first law speaker ever to be on time with your allotted 20 minutes. So much appreciated. As I mentioned, we do have time just for 2 questions for Caitlin because she won't be able to stay for the duration of our panel discussion. So we can take those now and then we'll transition to the rest of our panelists. Byron.
Hi, my name is Byron, and I'm a student of DNAP in International Environment Law. Spoke on various submissions on factual record, and I had a question relating to the illegal trade on ozone depletion substance. How do international cooperation, particularly with respect to the enforcement on Montreal Protocol, like be strengthened with respect to tackling illegal trade in depleting of ozone substances like hydrofluorocarbons?
So did you hear that, Caitlin?
No, I heard something about environmental cooperation though.
Well, that's in the right vicinity. So he was asking a question about the Montreal Protocol and what this agreement can do to address illegal trade in CFCs.
Oh, that's an interesting question. Despite being based in Montreal, I don't deal with the Montreal Protocol, and except mentioning it as an incredible success story of international cooperation, I unfortunately can't give more detail there, but it sounds like it may not be such a success story, and there might be something I need to read up on there.
Yes, Rob. Professor Glicksman is, I do want to take a moment to recognize Professor Rob Glicksman, a senior environmental law professor in our program. I won't guess how many years it's been, but I think in the vicinity of 15 years in our program. And we're very fortunate to have him, and we're fortunate to have our former Associate Dean, Lee Paddock, in the room. And I do recall how long he served as Associate Dean of our program, because I can't imagine lasting that long myself. So he was 2007 to 2019 as Associate Dean of our program, which is really quite remarkable. We owe a debt of gratitude to his leadership and durability in this very demanding role. So it's great to have you with us. So Professor Glicksman, your question.
And I wonder if you could tell the audience what the bottom line is when factual record finds that there has been a violation. Are there any sanctions? And is there any way to assess the success of the submissions process in achieving its goals?
That's a great question. So first, I'll just point to, we commissioned a long-term impact assessment that was prepared by the Environmental Law Institute, and we recently published that in January of this year. So you can dig around on our website, it's there, and that really reviews the history of the mechanism from 1994 to, I think we had to cut it off around 2022, looking at, is the submissions process meeting its stated objectives? And the results were a little mixed, like, I'll be honest, but there's a lot of interesting detail in that report that I won't try to get into here. I will point to a recent example though. I had to cut this slide, but we published the first factual record under the USMCA this spring in April, and it dealt with the loggerhead turtle in Mexico in a small specific area called the Gulf of Ulloa. And the submission was focused on bycatch of loggerhead turtles and also just these large mortality events that have been occurring in the area. So as we usually do, we put together all of the information. Our factual records cannot make conclusions. We can't make recommendations. We can't hand down sanctions. We can't mandate any of the countries to do anything. We basically just assemble all of this information. But I will say, here we are 6-ish months later. And on September 10th, NOAA just announced that it is revoking port privileges for Mexican flagged vessels fishing with gill nets in the Gulf of Ulloa, specifically because of bycatch of loggerhead turtles. Now, Mexico had been negatively certified under the under NOAA's process for that, which I believe is under the High Seas Drift Net Moratorium Act. Don't quote me on that. But they had been negatively certified last September and had been in a process of trying to follow some corrective action. And then were again sort of the consequences were stepped up here just about a week ago in having their port privileges revoked. So I can't say for sure that people at NOAA looked at our factual record and that went into the decision process to kind of step up the pressure on Mexico related to loggerhead turtle bycatch. But all I can say is we published the factual record and now we've seen this escalation from the United States and very specific to this geographic area and this issue. So.
Thank you, Caitlin, for that very informative response and presentation. One, if you could answer in 2 sentences, one thing that struck me on your slides was this idea of environmental law being defined differently among the 3 countries. And given we have so many students in the room, I thought that was something that would be an interesting point to note and comment on. So I'm interested in your very brief thoughts on that.
Yeah, so the former agreement allowed the submissions process to look into federal law, state law, even down to local and municipal law. And so we have like old submissions, even old factual records that dig all the way down into those levels. But in the USMCA, they decided to restrict it just to federal laws, essentially. And so it needs to be a law or regulation that's enforceable by the central level of government. In the US, obviously that changes things a little bit, but we do have really strong federal environmental law statutes. So there's plenty for submitters to work with. And the same is the case in Mexico. Really, I would say the change is in Canada. In Canada, the provinces have substantial authority, particularly over environmental matters. And so a lot of environmental law in Canada is at the provincial level. So restricting it to the federal level has kind of taken a few things off the table for Canadian submitters. And so that's why our current submission from Canada deals with just the Fisheries Act and the Shipping Act, which are 2 main federal pieces of legislation related to the environment and shipping activities.
Thank you so much. Great answer. Please join me again in thanking Caitlin McCoy for joining us today.
Thank you so much for having me.
Jency, you are next.
All right, good day, everyone. I hope you all can hear me. Yes, all good. Okay, so let me first begin with an acknowledgement of country, which is something that is a custom that comes from Australia, which is where I'm from. So that's where I grew up. But it's basically an acknowledgement and a paying of respects to the traditional inhabitants of this lands. And in terms of at least the lands that we're on here in Washington, D.C., it's a peoples who are known as the Anacostans or the Nakostanks. And so I pay my respects to them as part of that custom that I bring from Australia. I would also like to extend my thanks to Dean Matthew for the warm welcome that we received earlier, but also to Assistant Randy Abate for embracing this crazy idea of bringing all these fellows back together, which I had a little while back, and he was just like, yes, well, let's do this. This is a great idea. Also to the wonderful community of DW Law colleagues who are here today. It's so nice to see you all. I have missed you all very much so. And I'm really thrilled to see all your familiar faces. Now, in terms of this eager student body that's here, I'm so happy to see you. You have no idea how difficult it is to do a presentation to a room that there aren't many people in, or it's sparsely filled in. And as someone who was part of the GW Law Fellows program, this was something that we did quite often. We organized events for you all. And so it's very important to us that you show up and you appreciate that you're being here. So I really appreciate you being here. I really wanted to mention that. So today I'm going to talk to you about a chapter in a book that I'm authoring. I'm not authoring the book itself, but the chapter. And this is in relation to the BBNJ Treaty. Now, BBNJ, that, you might ask, what is that? You might not have heard of it before, or you might already know. Now, as environmental law students who are here, I'm sure you had your taste of environmental law acronyms, right? There's a lot in our field. But guess what? International environmental law has its own smorgasbord of acronyms as well. And BBNJ just happens to be one of those latest new ones out there. So BBNJ stands for Biodiversity Beyond National Jurisdiction. It refers to an agreement that was concluded just in early March last year, and it was adopted in June 2023. Now, the agreement is on the conservation and sustainable use of biodiversity beyond national jurisdiction. It's also known sometimes as the BBNJ Agreement, or sometimes it might be known as the High Seas Treaty. And given how new the treaty is, the book that this chapter is part of is really intended to be a very timely and authoritative commentary on what is the analysis of the treaty, some assessment of it, but also any commentary on how the BBNJ Agreement might have more international repercussions. So my chapter specifically looks at how the agreement intersects with international environmental law, and that is a pathway that goes both ways, right? There's international environmental law's influence on the agreement itself, and of course the agreement as a function of international environmental law, then influencing the development of future international environmental law as well. So before I go a bit into that, let me tell you just a little bit about the treaty, and also why do we even need this treaty? So it was on Christmas Eve in 2017, and it was the UN General Assembly. They had this resolution that came out, 72-249, and they decided they were going to convene an intergovernmental conference that's going to look at how can we create a new treaty or a new agreement that will fall under the auspices of the United Nations Convention on the Law of the Sea, the Law of the Sea Convention, right? And the intention was to come up with some kind of text for an international legally binding agreement to cover this area of biodiversity on the high seas that had not really been covered to a very well, in a good extent until this moment. So for those who may not be familiar with the Law of the Sea Convention, this is basically the constitution for the oceans, if you had to think about it. But as like all constitutions, you kind of need to think of it, and it needs to adapt in its times, right? So the Law of the Sea Convention, when it was first created, did not really, envisage some of the environmental challenges that the ocean faces today. It also didn't envisage the technological advancements that might come out of it. So like thinking about what are marine genetic resources and what are the contributions that it can make to perhaps a pharmaceutical industry or any other important, so for instance, like natural resource minerals, how we use our electronics, for instance. So this was all not really contemplated under UNCLOS. And really the last agreement that sort of came out of that UN Convention on the Law of the Sea regime was back in 1995, and that was the Fish Stocks Agreement. So since then, 1995, a number of gaps have been, they've discovered some gaps along the way, gaps both in coverage and also in implementation of how the high seas regime works. And so the 2017 decision that was by the UN General Assembly was really to create this new treaty under the UN Convention on the Law of the Sea. And even that, it was already a long time in the making. Ever since 2006, the UN General Assembly had been mulling over what are the gaps that we have here, what are the issues and the challenges that's currently facing the UN Convention on the Law of the Sea regime. And especially they were looking at questions of how do we conserve marine biological diversity that's out in the high seas, that's not within territory, like the jurisdiction of state parties. And also how do we ensure then the use of resources that are available in the sea, in the oceans, and to do it in a sustainable manner. a major part of the challenge of trying to address this issue is sort of the general context in which the issue emerges itself. So we still know very little about the high seas and also the deep seabed. There are the ecosystems there that cover more than half of our planet. But what we do know is that the human impacts have already had major negative consequences on the ocean everywhere. And it's been particularly seen on the high seas itself. So we can think about some of those examples, right? We got plastics and waste that's been accumulating in the plastic gyres in the Atlantic and the Pacific Oceans. You can see ship and land-based pollution that was just shown in Caitlin's presentation. And these kinds of pollution is affecting ecosystem functioning within the ocean. Global warming is, of course, heating up the ocean, and we're seeing ocean acidification, bleaching of corals, and of course, all of these are putting pressures on marine life. At the same time, as I mentioned earlier, scientists have also discovered really valuable new resources in the high seas. Hydrothermal vents, for instance, are host to valuable minerals that we use in our electronics. And of course, these vent systems are in turn home to a lot of marine and marine resources and animals. Some of those have the potential for pharmaceutical value, biotechnology value, and so forth. Then, of course, there's also our demand on fish, which is to a large extent not sustainable. Heavy exploitation of certain species have really taken our stocks of particular species to the verge of collapse. And while modern fishing techniques like bottom trawling is destroying some of those seabed ecosystems that you find in the deep sea. So what do we have in terms of what is the existing framework? Because that kind of tells you where some of those gaps are. Now, there are definitely certain challenges that are already existing, and then more that are emerging as we find out more information about the oceans, but also how oceans interact with some of the environmental problems that we have today. So under the UN Convention on the Law of the Sea, coastal states have jurisdiction over living and non-living resources that are within their exclusive economic zones, and also over resources that are on the continental shelf. That's been determined. So beyond that, UNCLOS, the UN Convention on the Law of the Sea, states that the International Seabed Authority is really what's going to manage anything that relates to the exploration and also the use of the deep seabed. And of course, the waters beyond territorial jurisdictions, that's that high seas, freedom for all kind of thing. Now, Part 7 of the UN Convention on the Law of the Sea covers some of those rights and duties of states that are out on the high seas. And for instance, Article 87 makes it clear that the high seas are open to all states, and they have certain freedoms in doing so, right? Like you can imagine, freedom of navigation, freedom to fish as much as you want, freedom to lay submarine cables or pipes, construct artificial islands that we've seen like on the South China Sea, for instance, and undertake scientific research as well. So these freedoms are not unconditional, of course, and they have to be exercised with due regard to what are the interests of the other states and other rights and duties that are set out in the UN Convention on the Law of the Sea. So one of those duties relates to the protection and the preservation of the marine environment. And this extends, of course, to the high seas and the deep sea bed. So you can think of articles like Article 192, if you looked at the UN Convention on the Law of the Sea. It tells the states, hey, you are obliged to protect and preserve the marine environment. Article 194 then encourages protection of particular marine ecosystems that are fragile. And then we have Article 197, which then obliges states to cooperate globally to kind of reach consensus on rules, regulations, standards, practices, whatever that can be needed to protect and preserve the marine environment. Part 11 of UNCLOS is also important because it establishes that international regime for exploring and exploiting what we call the area, the seabed and its resources. The regime is overseen by the International Seabed Authority, that organization I mentioned earlier. And of course, the mineral resources in this area are then considered the common heritage of humankind under the UN Convention on the Law of the Sea regime. So the ISA is also tasked with developing rules and regulations to conserve the seabed environment. That's also what they're meant to be doing. And they're meant to prevent damage from any kind of mineral resource extraction that's going to take place, or exploration activities even too. And what this body is currently doing is developing regulations for deep seabed mining. So we'll see what's going to come of that. But these ISA, so International Seabed Authorities mining regulations, they don't apply to all activities out there on the deep sea bed, for instance. So if you're thinking about deep sea bottom fishing, that won't be covered under the ISA's authority. Marine scientific research won't be covered under that. Cable laying won't be covered under that. Ocean activities like ocean fertilization or geoengineering on the oceans, some of that won't be covered. So this is a huge gap with respect to what is covered under the UN Convention on the Law of the Sea. And so in terms of, especially if our interest is in managing and preserving the marine resources that are out there, then there's already a gap that's within the current existing regime. There's also another range of global and international treaty and regional treaties that regulate specific areas of the marine environment. We can take, like, for instance, fishing. There's regional marine fisheries organizations. There's also like a particular regional ocean-based treaties that are there as well. There's ocean dumping that comes from ship pollution, for instance. And there's also navigation, like the International Maritime Organization. But these are all sectoral treaties, right? And so they're all independent treaties of the UN Convention on the Law of the Sea. So it means that state has to actually sign and ratify and join that treaty separately. It's done, and whatever's binding is in relation just to that agreement. And even if you're part of UNCLOS, but not part of that agreement, then it doesn't matter, right? Whatever's covered there is not applicable to you. So the problem of governing these marine areas that are beyond national jurisdiction is particularly more complex as a result because of these patchwork of international environmental law treaties that intersect in this space. So there are other organizations, like I mentioned, there's the regional marine fisheries organizations and the International Maritime Organization. But what they do is they address various activities on the high seas, but they're specific. And there are gaps in their coverage. They're sometimes limited by geography. So they're saying if we're only covering this Atlantic region, so the Pacific region might be not covered, or the Southern Ocean in the Antarctic might not be covered, for instance, under that particular regime, but it might be covered under another regime. Then it might only be covering certain species. That happens as well. So you can see how there are gaps in both geographic coverage, there's gaps in the function, there's gaps in what is the purpose of it. So needless to say, I think the kind of indication that you should be getting is that we need cooperation, right? It's very important on this front, and it's cooperation between a variety of actors. And this is, even though it's instrumental, it's also lacking in many ways. And that's sort of why, again, that this treaty came about. But it also means that the treaty has to be responsible for that cooperation and to make pathways for that cooperation to happen in a really meaningful and effective way. So you can see that cooperation will need to occur between the BBNJ agreement and its umbrella convention, so the UN Convention on the Law of the Sea. You'll need to see that it has to also work with the implementing agreements of the UN Convention. So the UN Convention has two other agreements. It's the one that's fish stocks agreement that I mentioned earlier, but also relates to deep seabed mining. There's agreement there. So it has to work with those two as well. It also has to work with multilateral environmental frameworks like the Maritime Organization and any kind of shipping pollution like MARPOL. You've done any marine pollution treaties out there. But also it has to work with stakeholders, right? And there's a lot of stakeholders now that are interested in the ocean space. You've got lots more companies and private actors involved. We've got NGOs that are in this space. And of course, there's also indigenous interests as well. So from its early days of negotiating this BBNJ agreement, negotiating parties to the agreement were cognizant of this importance of these relationships. And they specifically thought that, yes, we need to be thinking about these relationships. We need to be thinking about how we can not undermine those existing ones, but help to build them up and make them better and think about how to improve it. And of course, as a result, the intergovernmental negotiations for the BBNJ agreements, they really sought to look at how they interplay with these agreements and also these institutions that are already existing. So following the 2017 UN General Assembly resolution, we saw really another half a decade of negotiations take place because that's how international environmental law works. Is it doesn't work at a fast pace. It kind of needs, but at the same time, this is actually, this in comparison to some of the other treaties in the past, this actually happened quite quickly. And that was a momentous feat for the High Seas Treaty. So the treaty text was finalized in June 2023. But the High Seas Treaty, it seeks to fill that gap that we have already in the high seas. And what it tries to do is provide somewhat more of a coherent and a holistic framework for looking at the protection of the ocean. This brings me to the crux of my recent chapter, which is how does the BBNJ agreement then how is it a unique product of international environmental law? So it begins with the reality of how the ocean is as a haven for marine biodiversity. The oceans are just this vast and complex environment. It encompasses so many diverse marine ecosystems, whether it's coral reefs to estuaries and so forth. But the concept of an ecosystem in itself is really quite man-made. And our understanding of that also continues to evolve as science evolves. So it's really trying to grapple with, we're trying to have law grapple with something that it's very hard to put these human sort boundaries on it. So the UN Convention on Biological Diversity is really important in this space as well, because it has sought to produce sort of a legal understanding of what biodiversity might mean in our current state and how to protect it in a global community. So this is then overlaid by those territorial jurisdictions that we set through our international law, whether it's on state-based jurisdictions or whether it's in the ocean system that sets those boundaries within the UN Convention on the Law of the Sea. The problem is that it doesn't all marry well with what the nature is, right? Oceans don't see these boundaries that we set. And of course, the pollution that enters the ocean doesn't also see those boundaries that we set. So this becomes even more complicated, and which makes it less conducive to really responding to the human-led kind of boundaries that we set. So accordingly, the conservation and the sustainable use of biological diversity, marine biodiversity in areas beyond national jurisdiction is one of those topics that straddles not only the law of the oceans, but also international biodiversity law as well. So if you look at the final form of the BBNJ agreement, it's quite novel in that it is rooted in both the law of the sea and also in the frameworks of multilateral environmental agreements, like the UN Convention on Biological Diversity. So if you look at, the agreement, the BBNJ agreement, as I mentioned earlier, is the third implementing agreement under the UN Convention on the Law of the Sea. It, as a result, builds on a lot of the convention's existing principles, some of its mandates, but also expands on some of those principles as well. So for instance, the agreement adopts the Law of the Sea's dispute resolution system that it has. It pledges respect to the balance of obligations and interests that are already set out in the Convention and the Law of the Sea. It looks at building on the Convention's provisions when it comes to environmental impact assessments as it relates to the high seas. And of course, the agreement also builds on the Convention's capacity to help with building capacity and technology transfer. At the same time, the BBNJ agreement also adopts some elements of the Convention on Biological Diversity, right? There's some founding principles that comes from the convention, from the CBD, and also some elements of its institutional framework. So the BBNJ agreement, for instance, draws on a range of existing international environmental law principles, like the precautionary principle, which perhaps you have already studied in your international environmental law class. It also looks at the ecosystem approach, and they use that to then have as guiding principles within the BBNJ agreement, so that when the text of the treaty then has to be interpreted or implemented, they can then look to these guiding principles to provide how that interpretation implementation occurs. And of course, the precautionary principle is one example where there's been divergent views on whether it should be a precautionary principle or a precautionary approach. And so you'll see even within international environmental law, multilateral environmental agreements, there's different approaches that have been taken. The principle has a bit more strength in time, while the approach is a little less strict. And it looks at a few more other elements of what the context is. And so the BBNJ agreement, for instance, in this situation, they weren't able to make a consensus approach on whether, yes, we're going to go down the precautionary principle, or yes, we're going to go down the precautionary approach. So what did they do? They agreed to having both in the treaty. So it says it allows the state that's part of it to either adopt the precautionary principle or the precautionary approach as appropriate. And so this also provides you an idea of how even in international environmental law, there's elements of diversion, right? Even within established principles. And the treaty tries to accommodate that and tries to allow, and this is what is also important in consensus building, right? Negotiations are not an easy task. And so this is one of the ways that the chairs of the negotiations sought to try and bring everyone in by including both elements, because in reality, it doesn't have too much of a divergent impact. In addition, there's also the institutional structure. How am I going on time, Randy? 0. Okay. All right. So the only thing I want to mention then is that with the institutional structure, there's a secretariat, there is a conference of the parties, there's a scientific and technical body. None of these were included in the UN Convention on the Law of the Regime agreements before. So that is something very different when it comes to this new agreement, because it's really modeled itself off the CBD and other multilateral environmental agreements to try and make it a much more holistic, robust, and consensus-driven document. So I'll leave it there. Thank you very much.
As I mentioned, just hold your questions because we're going to have the 3 consecutive presentations and then questions at the end. Next is Nick Reiner. Good. Yeah.
Let me
Just
unshare. It has to be. Give me a sec.
Oh.
You're here, right?
Uh-huh.
Okay.
Okay. Well, thank you. It's so great to be here. I thought since I'm talking about regression that maybe I should just give this presentation backwards and sit down and look at the wall. But I wanted to be able to actually see what I was talking about. It's really great to be here. I'm so excited to be here at GW. I spent 6 years here. 4 as a student getting a JD and a master's at the Elliott School, and then 2 more as a fellow. And being the fellow was really a remarkable experience. A great 2-year period to be here in establishing my career as an academic. Really fantastic. And it's great to see Lee and Rob and Randy here. So thank you all so much. And thank you to Achinti for helping organize this, and Giovanna as well. It's been not quite 10 years ago. So about 9.5 years ago, I was right in the room right above this, L201. And standing outside on the first day of class, which I was co-teaching natural resources law, and I had changed the room. We were supposed to be in a different room, and I moved to L201 because the computer and the projector weren't working in the other room. And so I was standing outside waiting for the class in front of mine to get out. And one of the students in the class, looked at me and was sort of asking, "Is this natural resources law? And I'm not sure why we had to change rooms or what's going on. I don't know what the professor's doing." And I didn't really respond. And then I walked down to the front of the room and saw him do a double take when he realized I was teaching. So a really great experience to get my first chance to teach classes here at GW. So it's really great to be back here doing that again and getting to talk to all of you. So thank you so much for being here. I'm excited to talk to you all. And I'm glad Achinti spoke so much about principles in the end of what she was talking about and divergent applications of those principles. So if you think about the beginning of international environmental law at the Stockholm Declaration, at the time of the Stockholm Convention, the Stockholm Declaration, it's this list of principles that countries have agreed on to sort of lay out what international environmental law is, what environmental law is. And those principles at the time give a lot of flexibility for states to decide how they want to balance environment and development. And that's been a challenge ever since in really thinking about what the boundaries are when a country has established environmental laws, but wants to consider how to accomplish environmental protection at the same time as pursuing its own development objectives. And so, move it here. Okay. I just need to click on that. There we go. All right. Fast forward 50 years from the Stockholm Convention to 2022, when the UN General Assembly adopted the resolution recognizing a right to a healthy environment. What does that mean in the context of all of these principles that have been laid out since Stockholm in 1972? How does a country accomplish that following the principles of international environmental law and also recognizing this right to a healthy environment that the majority of the world's countries recognized in their constitutions. What does that mean in practice? If human rights are indivisible, interdependent, and interrelated, then what must states do to guarantee that right? Well, one thing that states have to do to guarantee human rights is the notion of progressivity, that human rights are supposed to be realized in a progressive fashion. States have to take progressive steps to fulfill human rights. And the corollary to that is non-regression. You can't go backwards. So once states have adopted laws or policies or regulations to guarantee the right to a healthy environment, what happens when they find something else that looks a little bit more attractive than environmental protection? Can a state go back on the environmental protection that it has guaranteed? Well, under the principle of non-regression, no, you can't. The idea of the principle of non-regression is that once a state has adopted an environmental law, that law can't be rolled back. It can't be removed. It can't be reduced unless there's an adequate justification for doing it. It's not an absolute rule. It's a principle, right? So it's a principle of non-regression that you can't undo the environmental law unless you have some justification that fulfills other rights that are, equal to importance with environmental rights that are recognized in the Constitution or elsewhere. And so this principle has been, developing over the past 10 to 15 years, and we see it more and more commonly in expressions in international treaties, in international soft law, and in domestic law. So this project that I'm talking to you about today is, I've written some about the non-regression principle, but I'm working with a colleague at the Universidad Externado in Colombia to do a study of Latin American courts and how they have applied the principle of non-regression in environmental law. So to what extent are courts actually applying this principle and engaging with it, applying it to particular situations in those countries? Let me skip that for just a second. So why non-regression? This progressivity, as I said, it comes from the early notions of human rights. The Universal Declaration of Human Rights says progressive measures, achieving progressively by legislation or other appropriate means the full realization of human rights. That's in the American Convention on Human Rights in 1969. It implicates a human right to go backwards on environmental protection. And when environmental protection goes backwards, that carries with it the potential for irreversible harm that also implicates the rights of future generations. So those environmental rights that could be considered here includes procedural environmental rights, substantive environmental rights, any law that guarantees access to information, public participation, access to justice. If you go backwards on that, that could be a regression in environmental protection, as well as protection of substantive environmental rights, environmental quality and human health, whether that's air pollution, water pollution, exposure to environmental hazards, or climate. Any of the laws that provide substantive or procedural protection, if you go back on those, any regression on that is going to implicate the human right to a healthy environment and other human rights. And all of these countries I'm going to talk about recognize a right to a healthy environment, and we also have that UN resolution that regulates that at an international level as well. So a few examples of this in international law before I get to these national examples. One that actually harks back to what Caitlin was just talking about a few moments ago. It's in the US, Mexico, Canada trade agreement, or the NAFTA 2.0. A party shall not waive or otherwise derogate from, or offer to waive or otherwise derogate from, its environmental laws in a manner that weakens or reduces the protection afforded in those laws in order to encourage trade or investment between the parties. So it's not, an idea like non-regression as a legal principle or legal concept. It's not pulled out of nowhere. It's not just merely aspirational. It's really there in a lot of international treaties. It's really there in a lot of international soft law. And then now we're seeing it come into play in domestic law. The Escazú Agreement on access rights with regard to environmental matters in Latin America, which just entered into force 3 years ago, also refers to the principle of non-regression and the principle of progressive realization, explicitly tying that to environmental protection writ large. The Paris Agreement talks about progressivity. Each successive nationally determined contribution is supposed to be a progression, which indicates that you can't go backwards in ambition as far as a country's projected contributions toward climate change. Non-regression comparative law. So I'm going to talk about Ecuador, Brazil, Colombia, Costa Rica, Mexico. I'm going to mention as many of these as I have time in the way that they've dealt with this in comparative law. And the point of the comparative analysis that I'm working on here is to really look at how deeply the courts engage with the principle of non-regression. So there have been courts that have been talking about this principle for a couple of decades, but that don't necessarily really seem to use the principle of non-regression as outcome determinative. Like there's some other reason to strike down the law or action at issue. And then they also mention that, hey, you know, it's important that this is in keeping with the principle of non-regression. So we're looking for examples of where courts don't just do that, but actually really identify like what is a regression? How do they define? So how do these courts define what is a regression? And then how do these courts define the test for whether a regression might be acceptable? Like, is there some justification for infringing on the right? Yeah, when might it be justified? Ecuador is an example that I think is worth mentioning. There's not a lot of jurisprudence on the principle in Ecuador, but it is written into the Constitution. The Constitution of Ecuador of 2008 says that any action or omission of a regressive nature that unjustifiably diminishes, limits, or annuls the exercise of rights shall be unconstitutional. And Ecuador, of course, has very strong environmental protections written into the Constitution, as well as a constitutional provision regarding the rights of nature. So that principle is really strongly written into the Constitution there. In Colombia, there's a history of jurisprudence going back 20 years on this issue. This is a case from 2009. Saying that a regression is presumed unconstitutional, but it may be justifiable. And the test that that court provides in that particular case, for a regression to be permitted or justified, the authorities have to demonstrate there are compelling reasons that make this regressive step necessary in the development of a social right. So if you're going to take a negative step that impacts the right to a healthy environment by withdrawing or limiting protection that has already been put in place, you have to show that there are compelling reasons for doing that in the fulfillment of other rights. So putting, you know, the right to the environment at the same level as any other right that's written into the Constitution. What was at issue in that case was a provision from the mining code on how to demarcate special protected areas for exploration mining activities. So the court in this case actually determines that there wasn't really a regression, but it gives us the rule of what would happen if it was. In Costa Rica, this case is older, going all the way back to 1998. One of the earlier instances of having a court really address this principle, where the court deals with a change in protected area. And the Constitutional Court of Costa Rica says that to reduce the size of a protected area, which would be a regression, you have an environmental law providing the protection for this particular area. And if you reduce the size of the protected area, you can only do that based on sufficient technical studies necessary to determine that that won't cause harm to or endanger the environment. So it's a different kind of test, right? The Colombian test says for it to be constitutional, it's got to be, you got to show compelling reasons that make this necessary in the development of social right. And in Costa Rica, they say it's about demonstrating that this action, like a technical case to show that this regression in environmental law or environmental protection is not actually going to do harm to the environment. So like, can you justify on a scientific basis why we no longer need to protect this area? You could think about this in the endangered species context, where if you were going to delist a species from the Endangered Species Act, you have to show that there's a scientific basis for doing so, to show that this legal protection is no longer necessary and won't cause environmental harm. Otherwise, you can't do it. In Mexico, another example is about a case that challenged a permit for construction within a protected area in the Laguna del Carpintero. And in that case, for the first time, the Supreme Court of Mexico really starts to expound on the principle of non-regression. The state is prohibited from backing down from that guarantee unless there's a proportionality test, which is to show that the regressive measure is proportionate to the benefit and the valid constitutional purpose that is being advanced by this change in the law. So it's a third different kind of test, not necessarily based on a scientific justification, but to show that there has to be some kind of proportionality. If you are diminishing this environmental right, what is it that you are accomplishing for the benefit of society? And can that proportionality justify the regression that's going on? Any significant and unjustified diminution in the present level of environmental protection will affect the inheritance we pass on to the next generation, the court says. In Brazil, I'm going to skip over to this case and talk about the one that is more prominent. In 2012, Brazil revised its forest code, which was a setback for the non-regression principle. Brazil's revision in 2012 was a significant watering down of some provisions, some of the stronger provisions of the forest code that required setting aside of areas for permanent preservation and legal reserves. It expanded the categories of activities that could potentially be authorized in permanent preservation areas, and provided amnesty for persons who had cleared forest prior to 2008. So that law was challenged. There was a constitutional challenge filed before the Supreme Court, the Constitutional Court in Brazil, specifically alleging that this 2012 law violated the constitutional right to a healthy environment. And the reason why it violated that right was in part because of the rule of non-regression, which was read into the Constitution. Not explicitly in the Constitution, but read into the Constitution. And one of the justices in the case, there were 11 justices in the court there, one of them wrote that this is a really difficult question for judges to understand what is or is not a retreat in environmental protection. And in a 6-5 vote, the court actually rejected the non-regression principle as a constitutional requirement in this case. The writing for the majority, the rapporteur in the case, Justice Louise Fuchs, wrote that legislators and agencies have to deal with scarcity in making decisions. So there was this concept that a prohibition of regressions would place too much restriction on the majoritarian popular will in deciding what to do. On the other hand, one of the dissenting justices wrote this really detailed point-by-point evaluation of several provisions in the code, noting which ones are regressions, which ones maybe aren't, and that implicate her test for what is a regression is, does it implicate the core of the human right to a healthy environment? And if so, then that's a regression that can't take place unless there's some adequate justification. So there's a lot to digest in those cases. There's a few different tests. Again, as I mentioned, like what would you need to overcome a regression? So our hope in putting together this study is that this can be instructive for courts all over the world, particularly in Latin America, but elsewhere, where the right to a healthy environment is recognized, to have examples about these kinds of tests. How can you apply the principle of non-regression and really make it effective, and get beyond sort of the, I guess, dichotomy of saying, no, you can't have any regression at all versus saying, under this sort of majoritarian concept that we can't prohibit the legislature from passing new laws or changing the law that they've done in the past, but to look at how you fit this in as a principle for courts to use. How can judges assess what is or is not a viable way to go forward when trying to balance the environment and other concerns? There are analogies in US law, and I know I'm about out of time, so I'm going to stop. But if you want to ask questions about that, I'm happy to talk about that as well. We have some statutory examples in the US where you can't backslide, but they're just written into the statute. They're not constitutionally mandated. So the Clean Water Act, the Clean Air Act have examples of what you can't do to backslide, but Congress could change that if Congress decided ultimately that it wanted to. So our application of the non-regression principle is not necessarily as strong as what you see in those other decisions. So ultimately, courts are engaging with the principle, some more than others, but there are enough decisions now to help really give us an idea of how to deal with that in the future. So, based on those tests, I think there are really good ways for courts to move forward and ensure that this principle is used to guarantee a right to a healthy environment. Thank you.
Randy, I think I only have 10 minutes. 15. Okay. Well, thank you very much for the opportunity to present my case. I'm going to present a case that was decided in 2023, and it's the case of La Oroya versus Peru. I like the case for several reasons. I'm from Peru. I was born in Peru. I was raised in Peru, and I follow up the case closely. And so I was very excited when the Inter-American Court of Human Rights issued the ruling on La Oroya versus Peru. And I'm going to arrive to some conclusions from the analysis of this case. And so I'm going to go from the particular facts of the case to general conclusions about current developments on the right to a healthy environment within the Inter-American human rights systems for the protection of human rights. So I'm going to talk first about the significance of the case, and then I'm going to proceed to talk about the background of the case, what facts gave rise to the dispute, and then the contributions of the case for environmental litigation within the Inter-American Court of Human Rights, and the contribution in terms of what is the right to a healthy environment, issues of causation, burden of proof and evidence, and finally, remedies available within the Inter-American human rights system in cases concerning environmental degradation. So why is this case important? This case is very important because it is the first air pollution case of the Inter-American human rights system. And it's the first case that involves non-indigenous peoples. As you know, the jurisprudence of the Inter-American Court of Human Rights on environmental issues has overlapped with the protection of indigenous peoples. So indigenous peoples frequently face land degradation, destruction of lands. And in that context, the Inter-American Court has found the states liable for violating the human rights of indigenous peoples to their collective lands. And by doing so, the Inter-American Court has protected the environment because it's necessary to protect the fundamental rights of indigenous peoples. But the environmental jurisprudence of the Inter-American Court has also dealt with the protection of environmental defenders and access to environmental information. So there is a jurisprudential line of cases concerning environmental issues. However, the La Oroya case versus Peru is the first air pollution case of the Inter-American human rights system that had set a precedent as the latest case on environment. So the facts of the case, very briefly, the case concerns a plant, a metallurgical plant that releases high amounts of carbon emissions, toxic emissions, communities located near the plant, and the operation of the plants for nearly 100 years. So we have a situation of 100 years of pollution, contamination, and communities located at the vicinity of the plant. And there's also a situation where the lands, the river, are contaminated as a result of air emissions. So it's not only about the right to health, but also the environmental degradation. So in 2023, the Inter-American Court of Human Rights found that the respondent state, Peru, violated the right to life, the right to physical integrity, the right to access environmental information, the right to public participation in environmental matters, and the right to effective remedies. It also found that Peru violated the right to a healthy environment. And this aspect is a central issue in the case, where the court, for the first time, defines what is the right to a healthy environment. So this is a definition that is provided by an international human rights court. And something that I would like to flag at this very early stage is that the American Convention doesn't protect the right to a healthy environment. It doesn't refer to the environment. There is no single provision in the American Convention that protects the environment. Yet the court says the right to a healthy environment as a self-standing rule is protected by the convention on the grounds that the convention is a living document. So I think that that aspect is interesting in that the Inter-American Court looks at a provision of the American Convention. And that provision is Article 26 on progressive realizations of human rights, progressive realization of economic, social, and cultural rights. So it's difficult to think that how can the court rely on a provision that is of progressive realization to enforce a right that is of immediate realization, which is the right to a healthy environment, because states have an obligation to protect the environment as a right of immediate realization. And as Nick said, well, you know, the environmental standards, environmental laws are of progressive realization, but that's true, but also some environmental laws, regulations, and principles are of immediate realization. And I argue that the right to a healthy environment is a right of immediate realization, yet the court is looking at a provision of progressive realization that doesn't even mention the environment. It doesn't mention the environment to enforce the rule against the respondent state. So that's one of the preliminary issues that I would like to raise at this point. The right to healthy environment, the notion of the right to a healthy environment is expansive. The court spends a lot of pages defining the right to a healthy environment. One of the interesting aspects of the right to a healthy environment is that the Inter-American Court says that the right to a healthy environment includes the protection of nature, as a subject of legal protection. So the right to a healthy environment is not only a human right to a healthy environment, but it's also a right of nature as a subject of legal protection. And I think that that definition is revolutionary, because for the first time, an international court is saying this human rights treaty is protecting nature, is protecting rivers, is protecting forest, soil as legal subjects. And I think that that definition of the right to a healthy environment will have repercussion in future environmental litigations before the Inter-American Court on Human Rights. The second aspect that I would like to highlight concerning this case is that when you read the case, it's very interesting because it's a human rights court that it's deciding a case based on a human rights convention to determine that whether the state violated the treaty. However, when you start reading the judgment, it's like if you were reading an international environmental law book, in that the judges elaborate on international environmental law standards to give content to human rights provisions of the treaty. What is the right to a healthy environment? Well, let's look at what international environmental law says about what the right to a healthy environment is. And so the court reaches out to principles, standards, and values found in international environmental law and imports them into in the process of interpreting the treaty, the human rights treaty. And it elaborates on the principle of prevention, the precautionary approach, the obligation to conduct an environmental impact assessment, the obligation to regulate, to supervise, and to remediate. All those principles are found in international environmental law, and the court articulates the environmental obligations of the state in terms of international environmental law. So in that sense, I think that this case, it's also interesting because the court reasoning reflects a strong cross-fertilization between international human rights law and international environmental law. And that reasoning, I think, will also have impact in future environmental litigation before the Inter-American Court on Human Rights. Another aspect of this case, it's the issue of causation and burden of proof, in the sense that the victim, the alleged victim of the environmental degradation, doesn't need to prove injury, And the court switched the burden of proof to the state. It is the state the one that has to prove that it did not pollute or it did not cause harm or injury to the victims. So the alleged victims do not have to prove anything. And in La Oroya versus Peru, what the court did is it ran three-step analysis in order to find the respondent state in violation. It identified a plant that was polluting the environment. Number one, it identified communities located near the plant. Number two, and number three, it found that the state failed to or authorize the activities or failed to prevent the pollution. After running those three-step analysis, the court concluded that the victims' rights under the convention had been violated. So you can see here that the switch of the burden of proof now is on the state when it comes to environmental litigation cases. Now, this approach is not new. The European Court of Human Rights have followed the same approach in air pollution cases. In Cordella and others versus Italy, the court switched the burden of proof and made Italy and required Italy to prove that it did not allow air pollution in the particular facts of the case. So similar cases decided by the Inter-American Court and the European Court concerning air pollution, similar treatment concerning the burden of proof and causation. So that's the second aspect that I wanted to highlight. The third aspect concerning La Oroya versus Peru is the issue of reparation, the issue of reparation. So in this case, the court awards compensation to the victims, right? But we know what's the issue of the victim. Professor, are they really the victims? Because they never proved that they were the victims, where the presumption is they are the victims and the court awarded compensation to the victims, in addition to a range of measures. It requires the state to fulfill, to adopt a range of measures to improve the environment, including the obligation to remediate the lands, the rivers, and air that had been harmed for decades. So the obligation to clean up, the obligation to remediate is part of the judgment in La Oroya versus Peru. And Peru has been given a deadline to report to the court the plan that it will implement in order to remediate the land. So these are the three aspects that I wanted to highlight concerning the La Oroya case. This case, I think, lays the foundation for future environmental litigation. I think that this case will influence the future of environmental litigation before the Inter-American Court. I think that in this case, the Inter-American Court, the judges of the Inter-American Court show an appetite to deal with issues of greenhouse emissions, to deal with environmental pollution, to deal with climate change. I think that this is the first case, and the future cases will build upon this particular case. The controversial issue for me, I think it's the use of Article 26 on progressive realization of economic, social, and cultural rights that is used by the tribunal to enforce the right to a healthy environment. I agree with the outcome of the case. I think that the court should enforce the right to a healthy environment, but I don't agree with the reasoning the court uses to enforce the right to a healthy environment by stating that the treaty is an evolving document, is a living document, and therefore the respondent state is bound to this particular rule. Yeah? And with this, I'm finishing the analysis of my case.
Okay, we've got 15 minutes for questions. Very interesting range of presentations, intersecting in very interesting ways as well. Start with Professor Paddock.
It's a question for Nick, and even though in the US federal level, anti-degradation provisions are the only thing we have. Montana, Pennsylvania, and a few other states do have constitutional protections for the environment, and at least in Montana and Pennsylvania, they've been read by the courts relatively broadly. I'm wondering if you're finding any hints of the non-regression principles in state constitutions in the US.
Thanks. That's a great question. I'd love to look into that. I'm not aware of any state cases that have directly raised that issue of whether you can do non-regression. But yeah, I think the same principles could and should apply in Pennsylvania and in Montana and Hawaii now. Yeah, I think that'd be a good next thing to look at.
The Pennsylvania Supreme Court's been somewhat active on that provision in the last few years.
Yeah. Yeah, thanks for the question. I think that's a really interesting idea that, yeah, in the US, there's definitely the potential to do that at the state level.
I would add that to the extent those provisions expressly reference future generations, I think there's more of an opportunity perhaps when Nick went through those versions of non-regression from each country. It seemed Colombia was the most protective. And in my view, it's still not protective enough, because if to the extent we're talking about what sustainable development means, it's behaving today in a way that doesn't impair the opportunity of future generations to have a sustainable future. And really, any regression in our environmental protection should be considered a per se violation of the right of future generations to inherit a sustainable environment. So I think Colombia is certainly on the right track with that provision, but I'm concerned that it admits of exceptions if we're serious about what protecting future generations really means. And I think Peru is certainly a leader with that reasoning from the La Roya case in terms of being much more ambitious about what it means to protect a human right to an environment, in the sense of looking at the rights of the environment itself as well. And future generations are very much that vulnerable community, the way environmental resources are themselves. The law can and should do a better job protecting all of those entities and the rights that they ought to have. Other questions? Tanya?
So you were talking about BBNJ, and it's for the framework is itself enclosed in the UNCLOS system along with the biological diversity convention. I was wondering, since UNCLOS established laws to adjudicate on matters where they were of dispute or there were legal questions of legal issues in UNCLOS, would that same apply for BBNJ as well, or like it has established another mechanism for it?
No, that's a really simple question, and they've adopted all the tribunal system. Everything that UNCLOS does will apply in the same way. Any dispute resolution system in UNCLOS.
Yeah, you had a question?
To geoengineering? Sure. So I think the most impactful way will be through the theme of environmental impact assessments. That's one of the main themes that the BBNJ, which I didn't go into, but it's one of the main themes that the BBNJ has an entire section on. And what it will be doing is looking into if there is going to be any activity, whether it's even within jurisdiction or outside jurisdiction, there's going to be an impact on the marine environment that's going to meet that threshold. And there is language in the treaty that says that if it meets that, then you have to do an environmental impact assessment. And so naturally, anything related to ocean geoengineering is going to very well fall into that category. And so they will have to go through an environmental impact assessment process. And that will include consultations with whether it's indigenous groups or any other stakeholders. And hopefully in that process, the opportunities and the challenges and the disadvantages, or I guess also the adverse impacts on the environment will come through in that process.
Are there questions? Yes, Elizabeth.
My question is for Giovanni. With the shift from the population proving harm to the nation or the industry proving no harm, does that then relax or release the obligation to show standing?
That's right. And from that perspective, there are several questions that will be raised, because are we talking about victims if they don't prove victim status, right? So in terms of reparation, how much should we compensate a person if that person hasn't proved to be the victim? And so there are different questions that are raised at this point with this new decision. Although, as I said, the switch of the burden of proof is not unique to the Inter-American system. The European Court has traditionally dealt with this issue and has switched the burden of proof to the state in view of the fact that the victims normally don't have access to the information that the state control. So how can we prove that you're the victim with blood tests showing high amounts of, I don't know, toxics? Yes. And so in the case of La Aurora, the population didn't have access to medical services. So how can we prove that they were impacted by the emissions? So a practical way to approach this issue is just making the state responsible to prove that they did not allow the contamination. If they allow, then we have a victim.
But that's a great question to think about in terms of compensation for environmental harms. I mean, we're used to the American system, and the 1Ls in the room perhaps aren't quite as familiar with that as others are, but this idea of standing as a barrier to access the court system to show that you're entitled to relief for harm. And so many environmental cases, and particularly global environmental harm type cases, strategic climate litigation cases, are thrown out on standing grounds. You're just not the right plaintiff to bring this case, therefore you're not going to be entitled to bring the case. And it's important to remember, outside our US-centric approach to these issues, is that there are many jurisdictions around the world that embrace universal standing. Basically, if you've got a complaint, you can take it to the courts. And the first reaction from someone from the US system would be, well, that's just going to create chaos. That's going to open the floodgates of litigation. And in fact, it doesn't. It's really an opportunity for meritorious cases to go forward without that standing hurdle. And it's really just people that are bringing cases out of genuine concern and not abusing the process and creating absolute chaos in the system. So it's out there more often than not, and it makes huge differences in terms of outcomes for environmental cases. Other questions? Yes.
My question is also for Professor Gatondi. In terms of the court's reasoning referencing this living document, kind of tying in that idea of regression, do you think that this will only be used to expand the limits of the treaty, or do you also see it potentially being reduced in the future?
I think that it's the first one. I think that it will be expanded. It's not easy though. I mean, the decision of the Inter-American Court recognizing the right to a healthy environment triggered dissenting opinions because the judges said the treaty doesn't protect the right to a healthy environment. Why are you saying to the majority that the treaty indeed protects the right to health? So it's, to me, it's difficult to support the contention that the treaty protects the right to a healthy environment. No, it doesn't. There's no mention to it. However, the court is pushing forward very strong to protect the environment, even if the treaty doesn't protect the environment. So I don't think that the court will change its view as presented in La Oroya case, because actually La Oroya case is a contentious case of the court. And previous to that, in its advisory opinion of 2017, the Inter-American Court already said the right to a healthy environment is a standard of the Inter-American system for the protection of human rights. It's incorporated in the American Convention. This is a living document. We are going to enforce it. And La Oroya case became the first case where the court decided to enforce it. So controversial though.
Lee, one moment. We have a question in the chat for Nick. Wondering if and this is from Professor Randy Hill, he's one of our adjunct professors at EPA. Wondering if the non-regression principle might be the basis for dispute resolution under USMCA.
Yeah, thanks for the question. Absolutely, it's there. I mean, it's in the treaty itself. So if the treaty itself has that language to suggest that no country can diminish their environmental law in the name of attracting investment, and that's an example that you see in trade treaties and investment treaties all over the world. There's a lot of examples of that. There's an article that I've read, and I'm forgetting exactly who wrote it, that really details all of the different treaties and investment treaties that include this form of this right. And I think that would be the basis for some kind of, dispute among countries.
Mr. Paddock had a question.
Yeah, it's a question for Ashinte, but before I do that, Randy, you were talking about standing that there are a few states in the US that have adopted what are called environmental rights acts. That's the Joe Sachs laws that came out of Michigan in the 1970s. Minnesota is particularly liberal in that regard. It's probably the broadest US standing law. It says any person, which can include communities or government agencies, can initiate a lawsuit for pollution, impairment or destruction of the environment. The environment's very broadly defined. So that's an interesting one to look at if you're looking at standing laws that are pretty broad. Ashinte, the question that I had is whether BBNJ enhances or reduces the potential for the U.S. to accede to the Law of the Seas Convention.
That's an excellent question, Lee. I think one of the most interesting things, at least with the BBNJ convention, at least with the negotiation text that came out, the US did sign that. They did sign on to it. So at least they can't go against the objectives of anything that's in the BBNJ. So this, I would argue, is like one of those first steps in terms of building, I guess, popularity, or at least consensus, at least within the US Senate on, okay, this is something that we should be thinking about. I think the fact also that there are opportunities for deep seabed mining that will come up that the US then cannot take advantage of is probably also going to be a source of pressure in the future. So I think, in my opinion, I think it's just a step, and it might be one of those, and I feel like it will be something that will pressure the US to then enter into UNCLOS later. But I don't think it's going to happen anytime soon, because we're not seeing ratification coming up very quickly with the BBNJ treaty yet.
And ratification has been on the table for decades in the US, and it remains this ongoing issue that has been the subject of debate for seemingly forever. And certainly the deep sea mining provisions of UNCLOS were a concern about ratification in the past, and sovereignty concerns as well. Typical kind of US, we do things our way and the rest of the world can figure it out for themselves kind of attitude, to, because there's really just no, if you're sensible, there's no good reason for the US not to be a party to the UNCLOS treaty. And it's really going to hurt us the more we remain on the sidelines with these major issues that we're confronting in the years ahead. One last question, Professor Glicksman.
International environmental law has recognized the principle of common but differentiated responsibility. Basically, it means that all nations are obliged to protect the environment, but the nature and scope of that obligation might depend on the extent to which economic development has already provided the population with a minimal accepted standard of living, so that developing countries which haven't yet achieved that, and whose history has produced less environmental harm than places like the US, maybe have weakened or lesser responsibilities than developed countries. So I wonder, for Nick and maybe for Giovanna, whether this principle could lead to a different set of justifications for departure from the non-regression principle in developing countries as compared to developed countries, or would this principle perhaps weaken the nature or provide more balancing with other rights in countries that are developing than in countries that are already developed, like the US?
Okay. That's a great question. The way I read and understand the CBDR, common but differentiated responsibilities, principle and idea in international environmental law is that it affects state obligations for matters of global concern, but I don't think that it applies to state obligations to safeguard the human rights of their own citizens. So I think that's the argument to make in response to that type of claim, would be to say that, yes, states have a common but differentiated responsibility in terms of how much resources they're required to put toward mitigation of climate change or adaptation to climate change, or even to the biodiversity crisis. Maybe you can make arguments there as well. But the human rights arguments, I mean, it's the concept of progressive realization might mean that they might not be as far along in guaranteeing or realizing a particular human right, but that the direction still needs to go toward progressivity. And so I think there are ways for advocates to push back on that kind of argument by saying that, no, that the human rights are indivisible, and you can't, as a human rights law concept, you can't make that kind of argument, even though you could in international environmental law space.
I agree.
Well, please join me in thanking our outstanding panelists. Thank you all for coming out. Welcome you to informally chat with our panelists before we head over to dinner.